The San Francisco Law Library's legal programs are intended to inform you about topics in the law and are not legal advice. Anyone can use the law library. We have law books and other resources on landlord-tenant law and many other topics. Visit our website sf.gov/SF Law Library. We are very happy to introduce today's topic and speaker. Here to speak about updates to state and local laws affecting residential tenancies is Richard Beckman. Welcome, Mr. Beckman.
Thank you, Aaron, and welcome to everybody who's joining us. I just want to mention a couple of things. One, I refer to this as the Aaron Parsons Project, for those of you who have some musical background. We're working together for the first time. I think Aaron saw this presentation, which I had given to the Alameda County Law Library a few weeks ago and asked if I would duplicate it here, which I agreed to do. I do want to add one caveat. I've been practicing landlord-tenant law for about 32 years, which is a couple longer than I expected. But about 25 years of that was in San Francisco physically and for the most part, client-wise. About 5 years ago, I joined a firm that was headquartered in the East Bay in Berkeley. And it seems that a lot more of my work has been in the East Bay, particularly during the pandemic. So the presentation you're about to see was based on the version I gave to the Alameda County Law Library with updates, obviously, for San Francisco. I've been a little less current with San Francisco law, so I've had to do a little bit of review on my own. And I want to say at the end, if I'm not able to answer your question confidently, just send it to me by email and I will answer it confidently that way, because I may want to go back and review some of the local ordinances and so on, whatever your question may involve. So that's my caveat. All right, and then with that, here we go. So and there's the overview, which we're going to basically cover. It's an hour seminar. I think most of the time will kind of going to be spent about equal shares between a little bit of overview of the state law, current grounds in San Francisco, and then some recent laws affecting landlord-tenant relations in San Francisco. And there is the big caveat, not legal advice. Seminar is not meant as legal advice, but rather an overview of state and local laws affecting residential tenancies and unlawful detainer proceedings. And otherwise, you can't take anything I say seriously. So starting with a statewide eviction protections overview, I want to actually skip ahead because really what happened was, and this is just going to be a little history lesson, you know, in March of 2020, when everything hit the fan and people were going crazy and nobody knew what was going on, every jurisdiction in California, as far as I could tell, passed emergency ordinances and legislations and moratoriums to prevent basically evictions of any tenants for any reason whatsoever, because like I say, things were just going through a phase when nobody knew what was happening next. So then in August of 2020, the California legislature passed AB 3088, basically tried to bring a uniform structure mostly to the non-payment of rent cases. You know, the state saw a difference between tenants who couldn't pay rent and who needed protection from unlawful detainer actions, eviction lawsuits, because there were so many people out of work in the service industry primarily. I think 50%, something like that. Initially, you know, all those places shut down and so on. So the state did, I think, a pretty good job enacting a pretty comprehensive statewide law that tried to address the issues, and it provided for a couple of different periods we're going to talk about just briefly. But one of its important things was it instituted a prohibition on local law being passed after August 19th through the period of the state law, which at this point was only December 31st of 2020. Just basically said no state, no local jurisdiction can pass an ordinance that affects the unlawful detainer procedure until the state law expired. And there was one little exception that said jurisdictions can pass new laws affecting landlord tenant if they don't have a rent control law already in place. But places like San Francisco, Oakland, Berkeley, you know, already had those rules. So we're covered by that restriction on basically a preemption restriction. So that is just that's that. And then the AB 3088 started out with a couple of different. I'm going to jump to a thing called the protected time period. So this was basically from March 1st of 2020 until August 31st, 2020. And this basically said, if a tenant just returned a declaration that said, hey, I'm sorry, I can't pay the rent because of COVID, the landlord was prohibited from taking any action against them in the unlawful detainer arena. The rent would still be owed and could be collected through small claims or superior court lawsuit, but it couldn't be used as a basis for an unlawful detainer for non-payment of rent. Also required 15-day notices and a variety of other things, all of which is, again, for the most part passed, but it's interesting to have the overview, I think. So then there was something called the transition time period, and this was from September 2020. I think it was originally through June of 20, and then it got amended to finally extended to September 31st of 2021. And this provision said basically a tenant could not be evicted as long as they returned the declaration and paid 25% of any unpaid rent by September 31st, 2021. As with the prior provision, the unpaid rent could be collected through small claims or superior court lawsuit. And the statute also amended the Small Claims Act to remove the $10,000 limit on amounts that could be sought through small claims. It basically made it unlimited if it was a unpaid rent COVID debt. So I'm going to go back. I probably okay. So that brings us to, oh, sorry, hold on. So the AB 3088 was followed by a couple of very similar statutes, first SB 91 and then AB 832. Basically, they continued the provisions of AB 3088 in terms of the limitations on landlords' ability to seek non-payment of rent cases or bring non-payment of rent cases. SB 91, I think, ended up going through July of 2021. And then 832 came through and extended it until June of 2022. But a couple of the most important things that both of those actions did was create a rental assistance program. And initially under SB 91, that rental assistance was limited to 80%, that the state would pay 80% of the landlord's unpaid rent or the tenant's unpaid rent, subject to applications and proof and so on, but only if the landlord would agree to waive the remaining 20%. If the landlord decided, I don't want to do that, there were all kinds of restrictions on the landlord's ability to try to seek the full 100%. So I think for most landlords, 80%, beat nothing basically. But it wasn't a popular program for obvious reasons. So AB 832 followed it, and it revised the emergency rental assistance program to provide for payment of 100% of the unpaid rent. And that obviously was much more popular. And then that extended through March 31st of 2022. So at the end of March of 2022, everybody was concerned that now suddenly all these eviction actions for non-payment of rent are going to be allowed and are going to start taking place. So the last in the line of ordinance was AB 2079. Basically, what it was designed to do was it confirmed that applications for rental assistance did terminate as of March 31st of 2022, that tenants couldn't submit applications for rental assistance after that period. But it also recognized that a lot of the applications that were already in the pipe hadn't been acted on. And so even though tenants may have applied and may be entitled to rent assistance, they weren't going to be able to pay a demand for rent. So AB 2179 did a sort of I don't know about a stopgap, but basically it confirmed that rental assistance applications were closed as of March 31st, but that through June 30th, the landlord still had to submit applications to the court confirming, or not an application, a declaration with any unlawful detainer saying whether or not the tenant had an application pending with the state or any local rental assistance program. If so, then the action could not go forward until that application had been ruled on. And it included a provision that if the tenant didn't cooperate, then the application would be the application being for an unlawful detainer summons would be granted. So the tenant had to cooperate. One of the things about that whole program that I always thought was pretty bizarre was that the rental assistance would be paid to the tenant, and when there was no provision that required the tenant to actually pay it to the owner. I mean, I think there's probably cases where the tenant got the rental assistance program and went somewhere else. So, and there was a lot. Landlords had a lot of confusion with it. And this was also, as you may recall, right after that giant hullabaloo about the workers' comp fraud, where they were paying people in San Quentin, for example. So that when this program was enacted with billions of dollars of assistance, there was a real effort to try to prevent fraud, which of course was just going to be like #1 thought in a lot of people's minds. So I think that effort frustrated a lot of landlords and tenants because the process, was again designed to try to prevent fraud, but it ended up preventing probably a lot of legitimate applications, or at least delaying them. So as of June 30th, all of that basically went away by state law. The right to bring a 3-day notice and an unlawful detainer that followed it for any rent due after April 1st was reinstated. So basically, after July 1st, by state law, you were back to sort of pre-COVID times. 3-day notice for non-payment of rent, no special pleadings that you had to submit to the court to get a summons issued. But of course, there were local jurisdictions that had their own restrictions. I mean, I will say, most notably, and I will say infamously, notoriously, that the entire Alameda County, along with the cities of Oakland and Berkeley, have enacted the emergency moratoriums that prevented evictions for any basis other than the State Ellis Act, or for situations where the tenant posed a threat to public health and safety. And those have not been revised, even addressed, as far as I can tell. And here we are almost 3 years into it. So there's a lot of frustration over there. San Francisco didn't take that tack. San Francisco did the moratoriums in stages, like for 4 months at a time. And one of the things that ended up sort of coming back, I think, to haunt them, because I think they would have preferred an East Bay model. They ran afoul of the state statute that said no laws can be passed locally that affect the unlawful detainer process at this point between August 19th and June 30th of 2022. The interesting thing about in the East Bay in Alameda County in Oakland, when they enacted their ordinances, they didn't put a time frame or a deadline. Well, they did, but it was December 31st, 2020, or the end of the local state of emergency. So in effect, it was open-ended. San Francisco's ordinances had specific dates, 3 months at a time. And it may have been because of San Francisco's charter rules or administrative procedures, I'm not really sure. So when they tried to renew some of their moratoriums after August 19th, there was a lot of debate, board of supervisors and city attorney, about whether those actions were preempted. I think eventually they concluded they were. And so they basically went with the state law that expired June 30th. Now, what happened on June 30th was, so this is, I'm going to jump here for a second. As of July 1st, pre-pandemic 3-day notice to may be used, no longer provide verifications regarding rental assistance. Now, it's interesting to note, verifications are still required to obtain a judgment or default judgment. Not really clear why. The statute itself doesn't make any mention of it, but the forms that the legislature created to enact these, or to help process these statutory provisions, these are judicial council forms, were amended on July 16 of 2022, and both state that they must be filed for submission of either the unlawful detainer summons or the default and judgment request. So, the only advice there is, you got to keep submitting those declarations, or you're going to get probably rejected by the court clerk when you submit your default request. So, jumping now to the current eviction status in San Francisco, basically, it's the same as state law, except San Francisco passed an ordinance I think in June, I have to go back and look, but I think June of 2022, that basically said all unlawful detainers for non-payment of rent after July 1st will be subject to a tenant's ability to defend that based on COVID, meaning if the inability to pay the rent is due to impacts from COVID, then that's a affirmative defense. I think there's actually some confusion, perhaps among practitioners that read that ordinance and say you can't even bring an unlawful detainer for non-payment of rent after originally it was July 1st. I'm going to talk about why it says April 1st now. Because they read it as saying, you know, this is a defense that the tenant doesn't owe the rent. But I believe the more accurate reading is it's an affirmative defense, meaning the landlord can bring the unlawful detainer for non-payment of rent, and it's up to the tenant to demonstrate that they have that defense, meaning they show through documentation that the reason they can't pay the rent is because their income or their finances have been affected by COVID. And that can be anything, you know, loss of job, medical payments, assisting family members. You have to look at the actual statute, but it's, you know, and I haven't actually, you know, had a chance to had a case just settled the other day that was going to trial where the tenant was, you know, making that claim, and rather than, as always, or as about 98% of the case, rather than put it to a judge or a jury, the parties decided to, you know, sort of hedge and both give in something. So haven't had a chance to have that defense actually tried yet, but I'm sure some have out there. Another ordinance that the city passed to try to address, well, this wasn't really so much COVID related. This is something that I think they taken from a couple of local jurisdictions, particularly Oakland, which several years ago passed what became known as the pre-notice notice. Under state law, as you probably know, a tenant who is in violation of the lease, whether it be non-payment of rent or breaching the lease in some other way or creating a nuisance, you know, can be given a 3-day notice. And that notice is either to cure or quit, or in the case of subletting without permission or nuisance, can just be a notice to quit, 3-day notice to quit. So Oakland instituted something called the pre-notice notice, which says that a landlord, other than in cases of extreme, you know, danger or threat by a tenant, have to give a pre-notice of 7 days to the tenant saying, hey, you know, you're in violation of your rental agreement, and if you don't take care of it in 7 days, then I'm allowed to serve you a 3-day notice to follow up as under state law. So San Francisco apparently finally got around to embracing that concept, and that is Ordinance 1822, as I'm reading, which became effective March 14th. That required landlords to provide a written 10-day warning letter and opportunity to cure before serving the formal 3-day notice for any ground under the ordinance itself. As is not uncommon, some of the local landlord organizations, property owners associations, filed a lawsuit challenging the legality of the act on various, usually constitutional basis, takings, or that's usually it. And the Superior Court, I don't know if this was Judge Haynes, I forget, issued an order temporarily staying it while he tried to figure it out, and then issued a final decision that said basically the city is allowed to institute that 10-day warning rule for all just causes except non-payment of rent. And the court, went through a lengthy analysis, and I think it makes sense. And basically said that the non-payment of rent is sort of the sine qua non of the relationship, and therefore it should not face this new local restriction. But breaching the lease in other capacities or the grounds can require a 10-day notice. So cities appealed it, but in the meantime, I think the ruling is you don't need a 10-day notice for a non-payment rent case, but for any other just cause ground. And that's a tenant at fault ground, of course, not the owner move in or Ellis Act or the grounds that don't include the tenant's actions. The agenda called for a alternative to eviction. And basically, that's a buyout agreement. You know, San Francisco, again, like most of the local jurisdictions now, I forget who started this one. Actually, it might have been San Francisco, because it's kind of funny. You know, Berkeley, Oakland, San Francisco, you know, are I mean, rent control started with Berkeley in 1979. San Francisco followed suit, I think, the same year. Oakland quite a bit later. And now, of course, pretty much every jurisdiction in the Bay Area has its own local form of rent and eviction control. But the buyout agreement, I think, the concept may have started in San Francisco, but basically it says that, you know, if you want to recover possession from a tenant and you don't have any basic reason to bring an unlawful detainer, or during the moratorium, when you were prohibited from filing unlawful detainers for pretty much any reason, except for public health and safety, then you could approach the tenant and say, hey, if you're interested in effectively selling me your tenancy, let's talk. The buyout statute is, I think it's Administrative Code section 37.9 C, or it might be 10. It's easy to find. It's under the 37.9 Administrative Code section. And it's pretty straightforward. You got to give the tenant a disclosure document that notifies them that they don't have to speak to you, that they can, let's go to that section. I think that's next. Yeah, a completed pre-buyout negotiations disclosure form, and before you can have any buyout conversations. And buyout conversations are defined to mean basically any communication that involves asking the tenant to move in exchange for money. So, and a lot of landlords don't know that, and they had that conversation. I don't know what the consequences are. If the tenant moved in exchange, and then there'd probably be some consequences, but for just initiating the conversation in violation of that ordinance, I haven't seen any actual repercussions to any landlord that's done that, because like I say, a lot of them don't know about it, and they might come to a lawyer and say, hey, I'm thinking about, you know, buying out my tenant or giving them some money, and then, oh, did you provide them the disclosure form? No. So then you give them the disclosure form, and hopefully, you know, the dust settles and the parties go forward. Again, if the tenant's not interested, the tenant doesn't have any obligation to respond. The tenant doesn't have to say, leave me alone. They can just ignore it. But if the tenant returns the disclosure form, and then they are free to have that negotiation. And again, the buyout statute is pretty easily reviewed. So I would recommend anybody who's interested in pursuing that particular option, you know, just review the ordinance. It's not one of the more complicated ones. Anybody can review it and understand it. And I will say this about the San Francisco Rent Board. First of all, they just recently changed their website, and I find it much more difficult to navigate. They had the same website for as long as they've had a website, and it was extremely user-friendly. You know, there were tabs at the top that basically guided you anywhere you wanted to go. They had a particularly helpful section called recent amendments or changes to the law. That one seems to have vanished, because that would have made my job a lot easier, because it really kept track of amendments to the ordinance, and it did it chronologically. You could go back and see when, for example, they used to have a new construction, you know, when the ordinance was first passed in San Francisco, any buildings built after the date of the ordinance, so July of 1979, were exempt from both rent and eviction control. And then the Costa-Hawkins Act was passed in 1996, 1995, which exempted any properties built after 1996 from rent control, not eviction control. And then a couple of years ago, San Francisco amended its ordinance to remove the new construction exemption. So that is, you know, those amendments were easily tracked on that particular part of the old website. Why they felt the need to completely revamp their website, and anybody out there that has any information, I'm just curious. I mean, it's nothing that's going to change. They're not going to go back. But, you know, it's the old, if it ain't broke, don't fix it thing. You know, I just want to know whose idea was that? And I'm sure there was some money spent on it, but that's a sidebar for our conversation today. So anyway, there's your buyout agreement provision. There's waiting periods before you can actually enter into a buyout agreement 30 days after you start the negotiations. It's got to be in language. I mean, it's got to be in writing, and it's got certain provisions that have to be in there. But, you know, the form is pretty easy to create because it You just copy the ordinance provisions, and it can be rescinded 45 days after it was signed. This is the one that so and I don't have any influence anywhere, but if anybody does, they might try to use it. So, under San Francisco rent control, rent stabilization, arbitration ordinance, the rent control ordinance, there are just cause grounds to allow an owner to terminate a tenant's tenancy and pursue an unlawful detainer, the eviction action. Unfortunately or oddly, the tenant's agreement to a buyout agreement isn't one. The tenant's violation of a buyout agreement isn't one of those just cause grounds. And I really don't understand that, because if the parties go through all this trouble the tenant has, the right to counsel, they have the right to have it reviewed, they have 45 days to rescind. I mean, it's a pretty, carefully crafted measure to protect tenants from basically sort of ignorantly stumbling into a buyout agreement when they don't have any idea what they're doing. And sometimes they require, the agreement is between the parties, but it can often, the tenant says, well, look, I can't move unless I get some money up front, like half of the 25 or 50 or $75,000 or whatever this particular agreement's going to cost. But there's no enforcement mechanism in terms of the unlawful detainer procedure. The landlord gives the tenant $20,000, half the buyout amount, so they can use that to relocate. Tenant takes the money and then decides not to relocate, either because they can't find a place or they just choose not to. The landlord is basically stuck going to small claims to try to get the money back, because there is no just cause ground that allows for an unlawful detainer based on the tenant's breach of a buyout agreement. I just personally think that's crazy, but that's the state of it, and maybe someday that'll change. So at any rate, there it is. It can be revoked within 14. Those are all the agreements. I'll just let you read that. And anybody that wants a copy, I think we're posting a copy of this PowerPoint presentation for those that attend and are interested in it. So some other recent developments, basically, the San Francisco requires that there be excuse me, interest paid on security deposits, and they issue a new rate each year. And now you have one that's effective March 1st of 2023. And that rate is 2.3%, up from 0.1% from the prior year. And this is from the Rent Board's website. This is how they calculate it. But you need to know, if you have a tenant with a security deposit, you got to pay them interest on that security deposit every year. And this is the new rate starting March 1st. And similarly, there's a rent increase announced as of March 1st that takes effect. And it's now going to be 3.6%. It's interesting because, it's not even the CPA. It's actually 60%, CPI. So landlords really aren't keeping up with inflation, because again, you get 60% of the consumer price index as a rent increase. Again, that's not whether that's fair or not. Under the state rent control law, AB 1482 that was passed in 1979, everybody was up in arms about that statewide, where there isn't, hadn't been rent control, but it's basically 5% plus the CPI. And currently that's 10%. I mean, I think that would probably satisfy most people, landlords anyway. So that's the annual rent increase news. Back rent. This was a confusing area for a lot of people. I think it may still be, but basically in San Francisco, if you can't pursue the non-payment of rent through the unlawful detainer procedure, and again, that has to do with rent that was due between March 1st of 2020 and August 30th of 2020. If the tenant returned a declaration, your only option was to try to pursue that unpaid rent through a collection action, basically, and whether it be in small claims or superior court. I don't know why anybody wouldn't go to small claims, really, given that there's no limit on the amount that you can assert or bring in that claim. Rents due between September 1st of 2020 and September 31st of 2021 were due 25%, and if the tenant paid the 25%, then you could seek the other 75% through the small claims process. Again, this is obviously money that is set off by any amount you've received through the rental assistance program. And but now, basically, with those caveats, any rent due after October 1st can be sought through the small claims court. It could also have been sought through the unlawful detainer process. So not really sure why anybody would not have pursued the unlawful detainer for non-payment of rent. I mean, again, of course, you have San Francisco now having this affirmative defense for COVID. But again, that's up to the tenant to demonstrate. And with, employment rates at 3%, whatever it is. I mean, certainly county, Bay Area wide, it's hard to imagine somebody saying, well, I can't pay the rent because I can't get a job. So I think it'd be interesting to see what people bring up to try to qualify for that defense. So those are some of those options. Let's see. So we just covered that. This is, and then this third section for LSI, so other laws affecting landlord-tenant relationships in San Francisco. Ellis Act notices have increased the relocation amounts. They're raised to now $10,000 per qualifying tenant, with a ceiling of $30,000 per household, and that's similar to the owner move-in concept. Not in the amount; it's less for owner move-ins, but the maximum of 3 tenants, per household. If you have 8, it doesn't matter. If you have 3, that's you maxed out per tenant. But yeah, 10,000 per tenant, 30,000 per household, and also the additional 6,700 for senior elderly people. Elderly or disabled tenants. And then March 1st, there will be a new amount. I don't believe that's been announced yet, so I'm a little surprised. Because I'll confess, I had an assistant help me with some of this, and so I'm looking at her work. So yeah, I'm surprised that it hasn't been announced as of yet, but apparently not. Other laws affecting a landlord-tenant relationship: the tenant's right to organize. That was last year, was passed by the Board of Supervisors, giving the tenants the right to basically, I guess, unionize in their buildings. And so they can create a tenant association. And obviously there can't be any retaliation for that. That one I probably should know a little bit more about. Gives the tenants basically the right to, collaborate on issues related to the ownership. And the accessory dwelling unit, this went into effect last year. Basically, as much as the city has tried to promote adding units, there was the law several years ago in which was ordinarily, historically, owners who wanted to add, a classic in-law, which were all over San Francisco, usually on the ground floor garage. Somebody carved out a little unit in the back with a bathroom and a kitchen. And those were all illegal, and they couldn't be legalized either for one or two reasons. Either because the property wasn't zoned for an extra unit, which you couldn't, I think, get a variance for, or in every case, you had to provide off-street parking, which was practically impossible. I mean, there was a company called Add a Garage, a friend of mine I knew, and he did really well, but mostly in Pacific Heights by lifting buildings and putting in garages for people in those areas. But for your average person in the Sunset of the Richmond that wanted to add an ADU or a little in-law, the idea of lifting your building and putting parking in was just it's practically impossible. So at that point, all those little in-laws, the ones that got discovered by the Department of Building Inspection, would receive notices of violation, either legalized or removed. And so you couldn't legalize, so you had to remove, which meant evicting the tenant would sue the landlord. So that's how that went. And then about 4 or 5 years ago, the city changed its rules and said, all right, we're going to waive the zoning issue. We're going to waive the parking restriction as long as the ADU, qualifies otherwise as meets all the housing code requirements in terms of ingress and egress and, ceiling height, those basic requirements, then we're going to let you have them. That was great, I think, for a lot of people. But this ordinance just says that you have to notify the tenant if you plan to actually propose one. And the tenant, I guess, can, oppose it. But that's just something to be aware of, I mean, and I'm sure if you actually go into the situation where you're going to add an ADU, your person that's going to help you do that is going to know about this, but that's just something that we thought we'd throw in here. This is just more of that. It's about how the notice must be given, what the tenants can do to try to oppose it, and so on. I don't think we'll go too much deeper into that. So another ordinance became, well, this is 2021, requires owners to report information about their units to the rent board. I know Alameda County just passed this, and there's a lot of angst about it, but I'm guessing for most San Francisco property owners, this is somewhat old hat. It requires all this information, but I think it also led to well, this is the new part that it was restricted to other units. Now it's buildings of 10 units or more, beginning on March 1st, 2023. So units, buildings with 10 or less units have to start reporting in March of this year. So that's the big change there. It just brought a lot more properties into that reporting requirement. But it also may have contributed to the Prop M, which passed in this November's election. And this says, if you leave your unit vacant, it's going to cost you. I think there's been a lot of concern that property owners are leaving units vacant because they don't want to rent under rent control. Either they're holding them in hopes of, I'm not sure what, selling. It's certainly not going to be that they're holding them in hopes that the rent ordinance is going to go away, because it's not. So at any rate, as you can see, starting on January 1st, 2024, that meet these qualifications, we'll start paying taxes on those empty units. And it will increase as time goes on. We'll fund, of course, to do subsidized affordable housing. Single family homes are exempt, as are duplexes. So according to the San Francisco Comptroller's Office, and this is an article from the SF Gate, 4,000, roughly 40,000 empty units, but about 4,000 likely to qualify for the tax. Other state laws affecting landlord-tenant relationships, AB 2559. This was a reusable tenant screening report, which isn't that big a deal. It basically says that if you're going to reuse, you can now reuse a tenant's screening report. If they got one from, if they're applying to different places, they can use that report and give it to a landlord of a new place that they're checking, and the landlord can use it. And if the landlord does use it, can't charge the tenant for it. Makes sense. As you probably know, landlords are entitled to charge a tenant a non-refundable fee up to about $55 now to run a credit report. But if you use one that the tenant's providing you, and it's usually something that has to be within 30 days, then you don't get to charge the tenant for it. Again, makes sense. Now, this is not, the landlord is not required to use the tenant's offered screening report. So it's really, I think, just like a nice thing for a landlord to do if they trust the tenant and it's a legitimate report. Then they can just use that and say that the applicant, because not every applicant actually gets the place. So that is AB 2559. There was another statute which I actually didn't include here that I had talked about in a different seminar, which a lot of landlords were sort of given sort of a red flag warning, oppose this. And it basically had to do with the amount of income that would be exempt from wage garnishment. And the way some of these alarms were published to landlords groups, it was affecting back rent, but it wasn't. It's just any judgment was going to be subject to fairly modest restriction. I think it changed from 20 to 25%, the wages that could be withheld. A modest thing, but I think again there was some disinformation about that it was being targeted to affect landlords' ability to collect unpaid back rent. That's more of the screening report, the reusable screening report. Again, AB 2559, and just kind of what we said, what it's got to include: verification, last known, be within 30 days, and landlord cannot charge if they use it. These are just things that were thrown in because they are new laws that took effect in 2020 or passed in 2022 to take effect in 2022 or 2023. I mean, this is regarding floating homes. I had a marina client for a while, and it's interesting, but unless you do floating home law, you probably don't care about this because that's what it's to affect. So I'll just let you know that it's there. Which if you do floating home law, you probably already know. Same thing. It's the the ability to of the floating home owner to have certain rights, and the landlord or the property, the marina owner, is restricted from certain actions. And then there was a similar ordinance, SB 940, that affected mobile home parks. Again, unless you do mobile home parks, this is probably not going to be of any interest, but we threw it in there. But if you do mobile home park or you have one, you should know about this. Really, it affected the January 1st, 96 was the Costa-Hawkins Act that exempted new construction from rent control, from local rent control. This basically has affected that, and it's now making that exemption only for 15 years rather than from 1996. So that was a benefit, I think, for the mobile home park owner. There you go. We have about 18 minutes for questions. I see there's some chat, and I think Aaron was going to try to read the questions. Aaron, is that correct?
Yes. So, can you hear me, Richard?
I can.
Okay, great. So please enter your questions. We've still got time. So are there any penalties for a landlord who collects disputed assessment charges by simply raising the rent?
Collecting disputed assessment charges. So these would be assessments from like the garbage service or the water service. I mean, those are the only assessments I can think of. So I'm not really sure. Well, no matter what it is, any effort to impose an additional to collect an additional amount from the tenant in San Francisco, again, if it's a rent controlled unit, which is pretty much everything except single family homes and buildings built after 1996, then considered a rent increase and would be subject to the annual rental cap. So if the annual rental cap is now 3.6%, you can either do a rent increase for that amount, or you can do something that reflects this assessment, which if it exceeded 3.6% would not be allowed. And if it were under that, would presumably leave you the difference for a rent increase. So not sure it makes much sense to do anything other than just your rent increase up to the maximum amount.
Thank you. So we need to please ask more questions.
Yeah, I don't have any. Let's see if I had any. What would it be? Oh, the one thing that I don't think the program covered, because when and I could actually do this as a screen share. The rent board's website says that the affirmative defense to non-payment of rent based on COVID economic impact is effective for rent due after July 1st of 2022. But if you go to the administrative code and read the actual statute, I don't know if they changed it and didn't notify the rent board, but it actually says April 1st. And the reason they originally put in July 1st is because of that preemption provision I was talking about under all of the variations of the state law, starting with AB 3088, ending with AB 2179, that prohibited local laws affecting unlawful detainer, or giving tenants additional unlawful detainer eviction protections until the end of the state law, which the last iteration was June 30th. So I think San Francisco drafted its ordinance in April or May to reflect that July 1st freedom to institute their own restrictions again. And that was the one they decided to enact. They didn't do like the East Bay and try to impose the drastic moratorium protections like no eviction for owner move-in or subletting violation or any violation other than public health and safety or the Ellis Act. But they did want to put in a provision that gave the tenant an option to defend the non-payment rent case because COVID affected their income. And at some point, they went back to the April 1st date, because that's when rental assistance was no longer allowed. And I'm not privy to those internal board of supervisor discussions, but that's the only thing I can think, because again, I just checked the rent board's website and it has the July 1st date. but the statute says April 1st. So I'm going with, if I'm a tenant, I'm going to assert my non-payment of rent case, is based on the statute that says I can defend non-payment of rent after April 1st because I've been affected by COVID. So just want to make that little note.
Thank you. And it looks like we have a few more questions. Please keep sending them in, everyone. Trying to get close to that hour.
Let's see.
So what do you do with a landlord who claims payments which have been regularly received for years are suddenly not being received, assuming payments were all made the same way?
Can you read that again?
Yeah. What do you do with a landlord who claims payments which have regularly been received for years are suddenly not being received, assuming payments were all made the same way?
Well, I don't really quite understand the question. So if a tenant has been making rent payments the same way for years and years, and suddenly they're not making those rent payments, is the question, what should I do about that? And if that's the question, I suppose the answer would be contact the tenant and find out what's going on, because it sounds like, they're a long-term tenant in good standing, and something may have happened, and maybe rather than just reflexively serving a 3-day notice demanding the rent and following it up with an unlawful detainer, if you don't hear from them, maybe it would be appropriate to reach out to the tenant and try to find out what's going on. Otherwise, I mean, if the tenant is obligated to pay the rent, whether it comes from the tenant or another some other entity, a third-party payer, like for example Section 8 or some other Catholic Charities. I mean, there are other sources of rental assistance beyond the COVID emergency rental assistance. And it's possible there's a bureaucratic, breakdown, which, that would be, that would create problems, obviously, for the tenant. I don't think I've ever had a client tell me that, hey, Section 8 stopped paying, but the tenant's still paying. I mean, the first question is, you got to contact Section 8, the administrator, and that's easier said than done. I mean, I know a lot of clients who've been extremely frustrated with the various housing authorities around the Bay Area, which administer the federal Section 8 funds and the program, that they're overworked, they're understaffed, nobody answers the phone, there's a caseworker that you can never reach. I understand that, but presumably somebody will answer the phone, and hopefully we'll have access to that particular tenant's file and try to explain what's going on. Again, if that's the question, and even if it's not the question, that would still be my answer.
Yeah, great, thank you. Next question. I wonder at what point the increasing burden of regulation by local and state government will amount to inverse condemnation. Are you aware of any cases filed under such theory to date?
Not a published decision. There's a lot. There's always discussion about that. I mean, if you're in a forum that sort of addresses a lot of landlord anxieties, that comes up. And there's a law firm that's particularly known for, I think it's called the Pacific Legal Foundation in Sacramento. They are pretty well known for bringing cases to assert property owners' rights. And if that issue could be asserted, they probably would have. And the constitutional challenges to rent control, which went all the way to the U.S. Supreme Court in 1979. The case Birkenfeld versus City of Berkeley. When Berkeley first instituted its rent control, as I mentioned earlier, in the Bay Area, it was challenged as an unconstitutional, as taking, deprivation of a violation of the constitutional clause, shall not impair contracts, the gamut. It went all the way to the Supreme Court, U.S. Supreme Court, which ruled that it passed constitutional muster, and they looked to the history of rent control in World War II. There was something called the Office of Price Controls, and it really had to do with all of the people that were moving to the Los Angeles basin to basically work in the munitions factories and the shipbuilding factories, and somewhat to the same extent the Bay Area, but Los Angeles seemed to be the focus. And there was a lot of concern about price gouging, from property owners, because now you have more people than property, rents. And so the federal government instituted rent control, basically Office of Price Control, and did just cause grounds. And so the Supreme Court looked back to that and how that had passed muster and said, well, if the federal government can do it, they didn't see any reason why a city, using its what's called police powers, which is not really having anything to do with the police. They need a new term for that. But it's basically the local jurisdiction's right to enact laws for its own public welfare, to take care of its citizens. And sometimes it infringes on some citizens' rights to the benefit of other citizens. But and there's different levels of scrutiny. There's something called strict scrutiny, which is like, it's really got to, it's a really constitutional right, like freedom of speech, freedom of religion. I mean, if you do something that affects that, it has the highest scrutiny. And then there's something called the rational basis, which is basically, if anybody could find a decent reason for this, it's going to pass. And they determined that the rent control jurisdictions, the rent control provisions basically just required a rational basis review, and said, okay, they passed it. So at what level does it become inverse condemnation? There's a lot of Supreme Court law on that too, under the takings clause. I mean, when regulatory restrictions so impact your ability to actually use your property for any purpose. And it's swung different, from one side to the other over the years. I think there's the South Carolina case where somebody bought property and then the county zoned it for marshland or something, and they're like, well, now I can't do anything with it except have an outdoor picnic area or something. And the court said, well, you're not deprived of all economic value. But again, that's a deep constitutional analysis that I'll leave to Pacific Foundation. But it would have to be pretty bad, let's just say, before it's going to be unconstitutional.
Thank you. What was the March 2023 deadline? I missed it.
Oh, that's when buildings under, we can go back, I think. That's when buildings under 10 units, here we go. So this is the units in buildings of 10 residents or more. They were started to report last July. Excuse me. For condominiums and units in buildings, I'm now right here in the middle, with less than 10 residential units. Reporting will begin March 1st of 2023 and every March thereafter. So this is, I'm guessing there's information about this on the Rent Board's website. And again, I'm still trying to navigate through that thing. But it's ordinance 265/20. And so you can, I think if you go to the Rent Board, you can always call them. I mean, they are helpful. Most of the Rent Board staff, do their best to address, tenants and property owners' questions. So I think you can go there and probably get all the information you need.
Thank you.
Here's something. So, all right, so this is interesting. In addition, the legislation requires owners to obtain a license from the Rent Board before imposing any annual bank rent increases upon tenants. Well, that's something you really want to pay attention to, because if you do rent increases and are not in compliance, just like any rent increase that isn't in compliance with the requirement of the rent ordinance, which says if you give a notice of rent increase, it's got to state this information. It has to tell, what percentage is the annual rent increase, what percentage is bank. And if it's not properly done, it's invalid. So if tenants pay rent, without knowing it's invalid, and then they later find out it's invalid, they'll get all that rent increase back, and the rent increase will be nullified. It'll go back to the rent it was. And I had a client, who did one, and it was 4 years later, tenants found out, and all that rent increase amount had to be paid back, and the rent went back, and then he was able to do a new rent increase that complied. But yeah, I would say this is one you want to pay. I probably should have highlighted this a little more, but I think this is one you got to make sure you're on the right side of, because tenants are pretty savvy. I mean, in the internet age, it doesn't take long to learn your rights, basically.
Great, thank you. And this is a follow-up, I think, about the payments question earlier. It says, no, the tenant made all the payments. The landlord refuses to acknowledge payment. It's a private landlord. Oh,
well, then this sounds like a tenant question, which I'm happy to address. I mean, proving payment of rent is just a matter of evidence. if and the same reason, I said if the landlord suddenly stops getting rent from a long-term tenant who's been in good standing, you'd want to find out what's going on. Same thing with the tenant. I mean, if the landlord stops accepting your rent payments, I mean, first of all, there's all kinds of problems that can be generated for the landlord for doing that. The tenant harassment ordinance, 37.10, has a lot of penalties and a lot of teeth to bite landlords who refuse to accept rent for some nefarious reason. So why the property owner is refusing to accept rent is just a question you got to ask the property owner. But as long as the tenant is paying it and can establish that, which is why you never want to pay rent by cash, I guess, or without getting a receipt. But yeah, I mean, there's so much scrutiny on these relationships now. I mean, I think landlords, used to have, and some still do this, feeling of sort of carte blanche with their tenants. It's my property, we'll do it my way. And then, the tide turned, dramatically with rent and eviction control. I mean, there's always been state law that provided the requirement of habitable premises and no retaliation. I mean, I don't know about always, but that's been state law for a long time. But the intricacies of the local ordinances, with really strict rent control, really strict just cause requirements, penalties for refusing to respond promptly to a tenant as opposed to just a rent reduction. I mean, the tenants have, obviously any landlord in San Francisco knows this, has a lot of options to make sure that the property owner toes the line. So for a property owner to refuse rent, that's a pretty big one. And there's got to be some reason, some explanation. If not, then the tenant, I mean, the owner is entitled to not accept the rent, but he can't proceed against the tenant for not paying it, I should say. So, again, that's an odd situation that somebody's just going to have to get a little bit more explanation for.
Okay, great. So it looks like we are about time. We have a few more questions. But Rich, if you
take one more.
Okay, sounds good. So we'll take one more last question here. Any prediction for the appellate ruling in the apartment owners challenge to CCSF's ordinance 18-22 on pre-note? There's an emoji there. I can't read it.
Yeah, it's
pre-notice mandate. We won't
Yeah.
hold you to your prediction.
We talked about that. Let's go. Just quickly run out to that. Yeah. So this is well, we can all follow it. And by the way, you can go to the first appellate before I answer the question. You can go to the first appellate district's website, and you can. There's an option to click on getting notifications of anything that happens in the case. And that's pretty nice because, you'll get an email from the appellate court. Hey, we made a decision, or, the respondent's brief has been filed or is overdue, or whatever the case may be. So, to predict, I think they probably will uphold the restriction on a 10-day notice for non-payment of rent. But the same issue was addressed in I think, Kim versus Alameda or Oakland Rent Board, because Oakland initiated this sort of pre-notice thing, and the judge, I'm pretty sure it was Judge Haynes here, relied heavily on that case to make the distinction that non-payment of rent. Again, when I said sine qua non, probably meaning the essential part of the relationship between the landlord has a duty to provide habitable premises, the tenant has a duty to pay rent. That's just in every unspoken, unwritten. It's just a matter of the relationship. Things about subletting and pets and alterations, those are all contractual provisions that are added by landlords to try to limit the tenant's rights. Because if there is no written, if you just have a tenant who just says, hey, I'll give you $1,000 a month for that, and the landlord says, okay, that's an oral rental agreement, but the tenant has the right to sublet. I mean, they can do alterations as long as they don't, commit waste. They can have pets, they can do pretty much whatever they want, again, without causing damage and what we call waste to the property. So landlords, which is why you have written rental agreements, you can't do this, you can't do this, you can't do that. And so that, I think, is what the court made the distinction on, that the non-payment of rent, is the essential part of the agreement. The other things can be handled differently. And I think that's how the court justified allowing the 10-day pre-notice notice on those other issues. I think it'll probably be upheld. I mean, short answer. The more interesting one, though, to me, and again, this doesn't affect San Francisco, but it affects a great deal of people in the East Bay, because Alameda County's moratorium, which is still has no deadline, no end date, applies to incorporated cities within the county. And that's really unusual. Normally, the county's jurisdiction extends to the unincorporated areas of the county. Now, San Francisco is weird because it is within the same physical boundaries as a city and a county. So I think it may be the only one in California. So Alameda County, like LA County, is huge, and it's got, you know, many cities within it: Oakland, Berkeley, Fremont, Hayward, you know, Alameda City. So the city of Alameda has rental property itself and was trying to bring an eviction action against non-paying tenants in its properties. And the Alameda Superior Court said, no, we have a local rule that says we can only accept unlawful detainer filings if they are either based on the Ellis Act or public health and safety, and non-payment of rent is neither of those. And so the city of Alameda sued the Alameda Superior Court on what's called a writ of mandate, saying you have to take our unlawful detainer because the county's moratorium should not extend to the city's jurisdiction. You know, it's just basic California sort of law. And I read the brief. I thought it was a pretty compelling argument. And so the court agreed that the Superior Court had to consider the city's application for a summons, for an unlawful detainer summons, based on their arguments that the county moratorium should not apply. Now, obviously, the county is the one that should have been opposing that writ, but so far, looking at the First District's website, I think they gave the Superior Court until February 3rd to agree that they would entertain the city's application. But the Superior Court could just say, well, we don't agree, we're going to enforce our existing rule, and then it will go back to the appellate court. And they should have just ruled on the underlying issue in the first place, which is, can the county's moratorium extend to incorporated parts of the county? I mean, that's the whole issue. But if the appellate court agrees that it shouldn't, then, you know, that removes the moratorium from all of those incorporated cities. Now, Berkeley and Oakland still have their own, but a lot of places don't, like Fremont and Hayward, the city of Alameda. And it's a ridiculously broad moratorium at this point, you know, in what remains of the pandemic. So that's the one I'm finding, you know, much more interesting to follow. But again, it doesn't have any impact on San Francisco. So well, that's I guess that's it. And you know, I will say I wish I were able to be much more like, you know, like here's new stuff, but you know, that's pretty much it.
Well, we want to thank you so much